Good afternoon. I'm Ernst van Zyl, Campaign Officer for AfriForum for Strategy and Content, and today I'm joined by Johan van Merwe, a lawyer and also the author behind AfriForum's comment or written submission on the new expropriation bill. So let's start off with one of the big questions out there regarding this bill, and that is, what is the difference between this new bill that's being discussed and that we made our comment on and the proposed amendment to the Constitution, specifically Section 25?
Okay, so basically there is a difference in procedure and a difference in substance. The difference in procedure relates to how the bill is made an act of Parliament or how the Constitution is amended. The bill is a normal legislative enactment, the kinds of acts that Parliament makes throughout its business. It basically just requires a simple majority in the National Assembly and then a simple majority in the National Council of Provinces to become an act of Parliament. The constitutional amendment is something a bit different. If it proceeds, it would be the first time that the Bill of Rights, Chapter 2 of the Constitution, has been amended. There has been 17 constitutional amendments prior to this proposed amendment, but this is the first one that a Bill of Rights, a fundamental human right, is being amended. The procedure is also a bit different in that there's a higher bar to amend it. It requires a 2/3 majority in the National Assembly, and 6 of the 9 provinces in the National Council of Provinces must approve the amendment. Now, the substance difference is that the bill, the Expropriation Bill, is the proposed amendment to the 1975 current Expropriation Act, which allows the expropriation of property for public interest and payment of market-related compensation. That's the current dispensation. What the bill tries to do is maintain the right to expropriate, but expand the powers of the minister to expropriate. So public purpose and public interest is now two separate instances, for example, where the minister may expropriate. But the most crucial portion of it is that introduces the expropriation without compensation component in the Act, which the 1975 Act currently does not have. What the constitutional amendment tries to do is that, as the Constitution now reads, it says that expropriation may occur in the public interest and upon payment of compensation either agreed or ordered by a court. Now, there are a lot of constitutional scholars that says that our current Section 25 already allows for expropriation without compensation, but that's not, in my view at least, correct. So what the constitutional amendment wants to do is to provide expressly that the right is limited internally within Section 25 to allow for expropriation without compensation.
Then also something that I think is of great concern to a lot of South African citizens is the question of what types of property will be affected by this new bill if it were to pass.
Yeah, the academics and the politicians, they try to create the impression that it's only farmland. So they want to right the wrongs of the past and say that where there's mass dispossession of property under the previous government, that is now redressed by this bill. But that's a bit of a double play. If you read the Act carefully, no, not even a careful reading suggested, it overtly states that. It defines property to say that it is property as defined in the Constitution. Now, Section 25 is clear. It says that property is not limited to land. So the constitutional protection of property expands to movable property and incorporeal property. Now, that is intellectual property. Patents, trademarks, goodwill, those kinds of properties also afforded constitutional protection. Now, by the Act including the constitutional definition of property into the bill, it states that the property that can be expropriated also includes movable and then incorporeal property. Another instance where the Act states, or the proposed bill states, that it's not limited to immovable property is in certain constructions in the section itself. You'll see that, take for example, where property must be valued prior to expropriation. It has a list of requirements that the valuator must comply with. And then it says, and if the property is land, then the following will apply. So logically it says that there is a certain list of factors that needs to be complied with, and then if it's land, a next set of values. Logically it dictates that it differentiates between when movable or incorporeal properties expropriated, and then when land is expropriated. So basically that includes bank accounts, it includes shares, it includes pension funds, it includes basically every type of property that you can imagine.
Now, I think you have touched on this matter to a certain extent, but I think maybe just to emphatically state, does this bill enable expropriation without compensation?
Yes, there's an entire section that deals with expropriation without compensation. So I believe it's section 12 of the bill says that when expropriating the property, just and equitable compensation must be paid. Now, then it says what factors we can take into account, or the state can take into account when making an offer of compensation. Then there's a particular subsection that says it might be just and equitable in certain circumstances, including but not limited to, and then it lists 5 factors that are the considerations that can be taken into account to allow for zero compensation. Now, there's basically 3 points of comment that is the most important in that respect. The first instance is the fact that it uses the word including but not limited to. So although it seems that only those 5 factors the bill lists is what can be taken into account when deciding to expropriate without compensation, it actually is not that limited. It says that the expropriating authority, and that is now national government, provincial government, local authorities or organs of state, can then consider a myriad of factors which we do not even know. It's overbroad and it can be argued to be arbitrary on that ground. But then 2 specific factors that are listed that requires addressing. The first instance, it says that nil compensation can be paid if you do not have effective control over your property. Now, control is not related in our law to property rights. So, for example, if you throw away property, it becomes what is known as a res derelicti. Now, for that to be appropriate, it means that you must relinquish possession and you must have the intention to relinquish your ownership over the thing. The Act does not require that intention part of it. It says that when you are dispossessed of your property or you lose effective control over your property, then it might be just and equitable for zero compensation to be paid. Now, instances where that can occur, land grabs, you lose effective control, or that you do not use the property as your primary residence, then you don't have physical control over the property, and that will allow the state to then expropriate without zero compensation. The other factor that is of note, what the bill does, is it also says that when you hold property only to profit from the appreciation of value over the property, zero compensation can be paid. Now, that is directly a property investment. A lot of people invest in property, but they don't actually live there. Under the bill, that means that is a factor that the state can take into account, saying, listen, you're not living there, so we'll just take the property without paying any compensation for it. Now, that's the more your upper middle class and upper classes type of argument. The same holds true for your lower middle class and upper lower class families. What happens there quite frequently is that people buy a piece of land, but they can't erect a structure immediately. So as they get money, they build the house and then they move in once the house is ready. Under this bill, unfortunately, it seems that if you don't have that effective control over the property, the state can expropriate it without paying any compensation.
Right, now moving from that, more of the legal process that this enables. What would that process of expropriation look like that is being enabled by this bill should it succeed?
All right, basically it works in 3 stages. The first stage is a compulsory investigation stage. So it means that the expropriating authority, that's now national, provincial or local government, must engage with the property owner to investigate the suitability of the property for the purpose of expropriation. So this entails that the authority contact you, they want to send evaluators to the property, they want to see whether or not the property fits the purpose for which they want to use it. Now here the balance of rights is quite equal. It says that the authority must negotiate with you, it must make contact with you, you can negotiate with it with regards to when the evaluators can come. it has a bit of a strong arm tactic to say that if you blatantly refuse to cooperate with the authority, they can go to court, obtain a court order against you stating that the valuator may come and value the property. So that's just the investigation phase. Then the second phase is the authority must serve you with a notice of intention to expropriate. Now here the balance or the scales start shifting. It says that, all right, now that the investigation has been completed, we give you a notice of intention to expropriate stating why we believe the property is suited for the purpose of expropriation, what kind of compensation we have in mind, whether or not it is going to be paid or not, and then of course the proposed date of expropriation. It has a long list of requirements. Now in this instance, it says that, okay, if you dispute anything, any aspect of this phase of the notice of intention to expropriate, the reason, the value, the compensation, etc., you may make written submissions to the authority to say, I do not agree with you. The unfortunate thing is in this phase, it says that the expropriating authority must consider it, but there's no obligation for them to reply to it. So you can give your comments, but there's no real effective mechanism with which you can then say, but did you listen to what I responded to in kind? Then the third step, and that is now the final step, is that they give you a notice of expropriation that says that, listen, we have now decided to expropriate this property. This is the effective date of transfer of ownership. This is the effective date of transfer of possession. And then that's the end of it. So the comments that you made in phase 2, if I can call it that, it need not reflect in the notice of expropriation.
So in the comment, or in AfriForum's comment, you mentioned the unconstitutionality of many of the sections within this new bill. Could you maybe elaborate on those specific sections and why they are unconstitutional?
So basically there are three. The first one is the broad powers to expropriate given under the Act. Now what it says that the minister, that's now the Minister of Public Works, can expropriate property on her own behalf or on behalf of any organ of state in the public interest and for a public purpose. Now the definition of those two aspects, public interest, includes now, for example, redistribution policies of government, those kinds of things, and public purpose is the important one. It says that for the administration of any act of parliament by any organ of state. Now that is basically every government department. It says that every government department regulates some sort of act of parliament. Under this power to expropriate, under section 3, it means that the minister can basically expropriate for any purpose. Now there's constitutional authority to the effect to say that such overbroad powers that are not internally limited itself can be declared unconstitutional. I think it was Justice Krichler that said that where we have limited instances of legitimate application, but there is potential for various other unconstitutional applications of such a broad power, the power is too broad and arbitrary and can be struck down as unconstitutional. So the first aspect is then the broad powers. The second possibly unconstitutional aspect of the bill is the transfer of ownership without judicial oversight. It ties into what is called in the bill the expropriate now, argue later point that we make. But basically what it says, there's a subsection that says that whether or not you dispute any step in the expropriation process, it does not halt the transfer of ownership. So if you have a dispute with regards to the value, the rationality, you want to review the decision to expropriate your property, even though you do that, it doesn't stop the expropriation from being effected. Now, if you do an analysis on other similar provisions where ownership is infringed upon in our law, there is a universal sentiment around how it must happen, and that is essentially judicial oversight. If you look at, for example, attachment orders where a creditor comes and attaches your salary to pay your debts, that must be authorized by a magistrate or a judge after a judgment has been granted against you. for tax purposes, for example, SARS has the power to attach your bank account if it believes that you're going to hide your money and not pay taxes, but a judge grants that order. When the police investigate crimes, they can seize the property which they believe was used in the committing of a crime, but after a magistrate or a judge has given a warrant to that effect. The most prevalent commercial instance of that is a mortgage bond. If you don't pay a home loan, the bank repossesses the property. But that is after a strenuous legal process and a judge orders the execution be permitted. So this will be almost this only act that effectively dispossesses ownership without a judge having any oversight of it. So the judicial oversight, or the lack of judicial oversight, is also a question of constitutional, of a possibly unconstitutional aspect of the bill. The third one is with expropriation without compensation is simply not constitutionally permitted. If you read section 25, it says that a state may expropriate property for a public purpose and subject to the payment of compensation either agreed between the parties or ordered by a court. So the word "and" there is very important. It says public purpose and payment of compensation. Even if it's a rand, there must be compensation paid. The construct of saying zero compensation simply does not fit into the language of section 25.
If this bill were to pass, what will the effects be for the average homeowner, no matter the size of the home or the location of the home, just those people that own their place of residence?
That is, in my view, the most unfair aspect of this bill. What it does is it says that, all right, let's say the state wants to expropriate your property. There's specific sections that deals with mortgage bonds and security. Now, most people do not have the cash to buy a house in full on their own. So they take a loan from the bank, they repay that loan with interest, but the bank secures its asset by registering a mortgage bond in favor of it. Now, the bill has a specific provision that says that when the expropriating authority expropriates the property, it receives that property free from any encumbrances. Now, that includes a mortgage bond. So the state doesn't take over your liability to repay the loan you paid to the bank. You still remain liable for that outstanding balance you owe the bank. And you have to pay that without actually having the property which you loaned the money for in the first place. Also, you're liable for any shortfall if the compensation does not match the outstanding balance that you have with the bank. Now, there's a separate section that deals with this specifically. It says that in the amount of compensation, let's say, for example, the expropriating authority has identified your house, then you have 30 days after you have been informed of the notice of intention to expropriate to inform the expropriating authority of any encumbrances on the property. Now, that is unfair for me, in the sense that the deeds office has a register of all the properties and all the encumbrances on the property. The state can just easily go look in the deeds office on the property it intends to expropriate under the investigation phase and realize that there is a mortgage property, a mortgage bond registered, and engage the bank with regards to the outstanding balance. So that's a reverse onus that's really just prejudicial to the owner. But be that as it may. Then the section goes further and says that the amount of compensation paid for the property to be expropriated can be negotiated to be paid to the bank directly. So you, the bank, and the state can then negotiate and say, okay, pay the compensation you'll pay to me directly over to the bank, settle my bond, and I go my merry way. So that's the perfect world. The imperfect world will say that what if that compensation paid is not enough, or the expropriated owner and the authority and the bank cannot agree to the terms of this payment? Then something very unfair happens. The state pays the compensation it unilaterally decides, which may still be pending a dispute. It pays it to the master of the High Court. It's the organ of state that deals with estates and deceased estates, insolvent estates. So basically, the state pays it to the master, and then it says, all right, under the powers of expropriate now, argue later, I have now taken the property, your money is with the master, you and the bank can then litigate amongst each other to determine who gets what portion of the compensation paid. So it saddles basically the homeowner, in the worst case scenario, it saddles the homeowner with two expensive lawsuits. The first lawsuit is to review or to fight the actual decision to expropriate your property. And then the state unilaterally decides, whilst that is ongoing, you and the bank can then fight amongst yourselves about who gets the compensation and what are the terms of that payment arrangement. So it's highly prejudicial to homeowners if the state decides to target you in that manner.
So in AfriForum's comment, you asked the question of whether there is a valid reason for a law that enables the state to expropriate the property of citizens without compensation, and you actually provide the answer to that as well. Could you give us more information on that?
The answer is no, but on many levels. Now, you're comparatively viewed. There are a lot of states that have the power to expropriate, but the question of expropriation without compensation features nowhere. So if you look domestically, as I've already said, Section 25 of the Constitution makes payment of compensation a peremptory requirement for expropriation to occur. The state must pay you before they can expropriate that property. Viewed internationally, if you now look at comparative analysis of constitutions, there is no such rights in the majority of countries. Take, for example, the United States of America. It says that you can be deprived of life, liberty, and property if it is subject to due process and subject to payment of compensation. The basic law of the Federal Republic of Germany says exactly that. It says the state may expropriate for public purposes, but subject to payment of compensation. Even our neighbours, the Botswana Constitution and the Namibian Constitution, also says that the state may expropriate, but it must be subject to compensation. So in the society of nations, that is not the norm, that the state has that unilateral power to expropriate without compensation. You can take it on another level as well, treaty-wise, on an international law level. If you consider, for example, the United Nations Charter of Human Rights, it protects property rights. Even the African Charter of Human and People's Rights expressly protects property rights and says that the state cannot infringe on your property rights. International commercial trade also, the IMF policy document says that if there's foreign investment in a country, the state cannot expropriate that property without paying compensation. That's now to benefit international actors. So on a preponderance of all the legislation that you can look at everywhere, nowhere does it say the state has the power to expropriate without compensation. The right exists, but it's the no compensation portion that doesn't really fit in the society of nations at all.
And I think the most important thing about this bill in regards to the critique of it and commenting on it is looking towards the future in regards to what the adverse effects of it will be on the broader society, on the economy, on the banking sector. Could you enlighten us on what these types of consequences might be?
Yes, if you read the commentary that has been published quite extensively by other institutions, farming associations, banking associations, the adverse effect, it will permeate basically every sector of society. There is commentary from the farming associations that says that if property rights in the agricultural sector is not secure, it means that the already strained food market or food industry in South Africa will be strained further. There are projections to say that the millions of South Africa that now live just above the poverty line will be below the poverty line as the adverse consequences of expropriation without compensation inflates food prices. What I focus on in the commentary is, interestingly, the Banking Association of South Africa's submissions. Now, these submissions they made with regards to amending Section 25. It was not a comment on the bill per se, but the statistics that they say and the argument they make can just as well be translated into a commentary on the bill. As I said previously, the primary function or the primary security method a bank uses to mitigate the risk in lending is the security it has over your immovable property. So the bank must remain liquid. It loans money from the Reserve Bank to loan to you. It must repay the money to the Reserve Bank. In order to make sure that it's able to meet that obligation, it secures the loans by way of immovable property. If that is no longer the case, there's an internal and external consequence in it. Internally, with the bank itself, BASA, that's now the Banking Association of South Africa, says the banking industry will collapse as a whole, because it means that all its loans, its liabilities will be unsecured. Now, if you just think about it practically, let's say the state comes and decides to take your home. Then you can decide to max out your bond, loan all the money, the state takes the property, and now the bank has to sue you for the outstanding balance. Is the bank really going to get all the money? Let's say you pay 2.7 million rand for a house. You don't have 2.7 million physically in your pocket. The bank is never going to cover its total exposure. So that's the first issue, is the security the bank holds. So on the bank's books, so says BASA, it will mean that both on their asset and liability books, there will be an entire collapse in their internal industry. Now, what they specifically warn of is that foreign investment is very directly linked to the integrity of the banking system. So then they predict further downgradings in credit ratings, etc. That increases inflation. So it is completely a roll-on effect. Externally, if expropriation without compensation is even a possibility, the bank will try to mitigate its exposure and be much, much more conservative in granting loans. So young people like you and I, who now soon become or already have become first-time homeowners, will find it much more difficult to find a home loan, because the bank has no guarantee anymore to say that if I grant you a loan, you'll be able to repay it. If you don't repay it, I take back the property and at least make whole my damages. But that falls away. So higher interest rates for first-time homeowners, it will be much more difficult to actually obtain immovable property under such circumstances. And it has a really wide knock-on effect. Immovable property is how most people leverage themselves out of poverty. So you have mother and father that paid off a house, you inherit that house debt-free. You can then leverage that house, take out a further loan to pay for tertiary education, to pay for your expenses. So people use property to leverage themselves out of situations. And if the banking sector collapses, or if the bank even becomes more conservative in lending, let's take the best case scenario and say the banking institutions remain sound, they will become conservative. And that means that all the people who try to raise themselves out of the lower class into the middle classes by using property, that opportunity will fall away.
So I would just like firstly to use this opportunity to thank my guest Johan van Merwe for sharing his knowledge with us regarding this bill. I hope that now that you have listened to this conversation, you have a better idea of what is contained within this bill, what the risks of it entail, what consequences it might have, and also I hope that you now know a lot more about the contents of AfriForum's comment on this specific bill. You can also do your part to help fight this bill by going to the website that will be on screen momentarily, or you can go to the link which is in the description, where you will be able to put your comments in and also comment on the bill. And if you don't have a comment, there will also be an option to send a comment that has been prepared. Finally, if you want to help out spread the message, you can also share this conversation on social media with friends and family, over WhatsApp, over messaging apps that you use, to make sure as many people are informed as possible, and also that as many people know what's going on behind the scenes. Lastly, thank you very much for tuning in. Thank you for taking the time to get yourself informed, and we will talk again real soon.